Same-sex marriage in Alabama. Restrictions. Executive Order. On August 29, 1996, Governor Fob James issued Executive Order 24 banning same-sex marriage and recognition of same-sex marriages performed in other states or foreign countries. Statute. On April 9, 1998, the Alabama State House voted 79-12 in favor of a ban on same-sex marriage and recognition of same-sex marriages performed in other states or foreign countries. On April 13, 1998, the Alabama State Senate approved the bill in a 30-0 vote. Governor Fob James signed it into law. Constitution. On March 8, 2006, the Alabama State House voted 85-7 in favor of Amendment 774, a constitutional amendment to the Constitution of Alabama which bans same-sex marriage and a union replicating marriage of or between persons of the same sex in the state. On March 11, 2006, the Alabama State Senate approved the bill in a 30-0 vote. On June 6, 2006, Alabama voters endorsed adding the amendment to the state's constitution with 81% voting in favor. Lawsuits. Aaron Brush v. Bentley. A plaintiff couple filed suit on June 10, 2014, seeking recognition of their out-of-state marriage. The due date for motions was set at July 31, 2015, to allow for action by the U.S. Supreme Court in other cases. Hard v. Strange. On February 13, 2014, the Southern Poverty Law Center filed suit in U.S. District Court for the Middle District of Alabama on behalf of Paul Hard, challenging the state's ban on same-sex marriage, both in its statutes and constitution. Hard and his late husband, David Fancher, Alabama natives, wed in Massachusetts on May 20, 2011. Fancher died in an accident on August 1. The suit, originally Hard v. Bentley, named the governor as principal defendant, as well as several other government officials. Hard asked for a corrected death certificate and recognition as Fancher's surviving spouse, entitled to a share of the proceeds of a wrongful death suit filed by the administrator of Fancher's estate. Fancher's mother, who opposed Hard's claims and was supported by Alabama Supreme Court Chief Justice Roy Moore's Foundation for Moral Law, asked the district court for a ruling on her motion for summary judgment on February 5, 2015. On February 9, the Alabama Department of Public Health provided Hard a corrected death certificate. On March 10, the court removed the governor as a defendant and stayed proceedings pending action by the U.S. Supreme Court in same-sex marriage cases then scheduled for review. On July 1, 2015, Hard asked the court to lift its stay and release the wrongful death proceeds, citing the U.S. Supreme Court decision in Obergefell. The court did so on July 15. Pat Fancher appealed the district court's ruling against her. On April 20, 2016, the 11th Circuit Court of Appeals affirmed the decision of the district court and ruled for Hard. Searcy v. Strange. Plaintiffs Carrie Searcy and Kimberly McKean filed a lawsuit, originally Searcy v. Bentley, on May 7, 2014, seeking recognition of their out-of-state marriage and second-parent adoption for their minor son. In mid-June, attorneys for the same-sex couple filed a motion for summary judgment. The state defendants filed a motion to dismiss. On January 23, 2015, Judge Callie V.S. Granade of the United States District Court for the Southern District of Alabama ruled that Alabama's refusal to license and recognize same-sex marriages as unconstitutional. She ordered the state attorney general to stop enforcing those bans. The plaintiffs' attorneys hoped the state would comply, though other LGBT rights advocates anticipated further litigation. Legislative leaders denounced the ruling of a single unelected and unaccountable federal judge or saw the ruling as evidence that traditional values espoused by Alabamians have begun to erode even in our conservative state. Attorney General Luther Strange immediately asked for a stay of her ruling. On January 25, the plaintiffs asked the court to clarify its order, describing the probate judges like George Wallace at the schoolhouse door staring defiantly upon this court's order. They cited at length a 1970 ruling involving the same group of government officials that had ended enforcement of Alabama's anti-miscegenation statute, United States v. Britain, which extended a ruling from one interracial couple who sought a marriage license and required the Attorney General of the state of Alabama to advise the judges of probate of the several counties of Alabama. On January 25, Judge Granade stayed her ruling for 14 days to allow Strange to seek a longer stay from the 11th Circuit Court of Appeals. On January 26, Attorney General Strange filed notice of appeal in the 11th Circuit and asked for a stay of the district court's ruling pending appeal. The governor and the Probate Judges Association filed amicus briefs in support of his request. On January 28, Judge Granade clarified her order, quoting at length from Judge Robert Hinkle's warning in the Florida case Brenner v. Scott that those who fail to comply will bear the costs of additional suits that will produce the same result, and still quoting Hinkle, there should be no debate on the question of whether a state official may follow the ruling, even for Strawser v. Strange. On January 27, 2015, Judge Granade ruled in favor of a male couple seeking the right to marry in Alabama. She stayed her ruling temporarily, setting the stay to expire on February 9 with her stay in Searcy. A male couple, James N. Strawser and John E. Humphrey, had filed their suit in September 2014 without assistance of counsel after being denied a marriage license at the Mobile County Courthouse in July. At a half-hour hearing before Judge Granade on December 18, 2014, each of them testified, and Strawser questioned their only other witness, Bishop David M. Carnreich, a minister of the United Gospel Holiness Church of America and presiding bishop of the Staff of Life Church Conference, who had married them on August 16. James W. Davis of the Attorney General's office cross-examined all three. On January 29, the National Center for Lesbian Rights took on the plaintiffs' representation. Reaction to Searcy and Strawser rulings. Granade's orders take effect. Granade's orders in Searcy and Strawser took effect on February 9. Just as state offices were opening that morning, the U.S. Supreme Court declined the state's request for a stay, with Justices Antonin Scalia and Clarence Thomas dissenting. 9 counties issued marriage licenses to same-sex couples that day: Chilton, Coffee, Crenshaw, Etowah, Fayette, Jefferson, Lowndes, Madison, and Montgomery. The first couple to marry were Tory Sisson and Shantwolf in Montgomery. The Searcy plaintiffs refiled the adoption petition that had been the basis of their lawsuit on February 9 as well. That morning, Attorney General Strange issued a statement in response to the Supreme Court's action disclaiming responsibility for the issuing of marriage licenses and advising probate judges to consult their own legal counsel. That afternoon, Governor Robert J. Bentley announced he agreed with Moore's statement and Thomas' dissent, but would take no action against any probate judge based on the issuance of marriage licenses to same-sex couples. Also that afternoon, the Searcy plaintiffs asked the district court to hold Don Davis, probate judge for Mobile County, in contempt for failing to open his marriage license division that day. The court denied that motion later that day because Davis was not a party to the Searcy lawsuit. Republican U.S. Senator Jeff Sessions commented on February 9, "I think it's an unhealthy trend that judges feel that they are somehow reflecting popular opinion when, first of all, it's not popular opinion, and secondly, who are they to be ruling on cases based on how they feel?" Further proceedings in Strawser. Ending the first day of legal same-sex marriage in Alabama, the Strawser plaintiffs, whose pro se suit had originally named only the Attorney General as defendant after they had been denied a marriage license in Mobile County, amended their suit to add Davis as a defendant and add 3 other same-sex couples seeking marriage licenses from Mobile County as plaintiffs. They also asked for a temporary restraining order or injunction preventing the defendants from enforcing Alabama's same-sex marriage ban and, for the first time in this case, sought attorneys' fees. The court added the new parties the next day and scheduled a hearing on the injunction for February 12. After the hearing, Granade issued an injunction against Davis, ordering the probate judge to issue marriage licenses to same-sex couples, and Mobile County issued marriage licenses to same-sex couples that afternoon. On February 16, Jefferson County probate judge Allen King, one of the 4 probate judges named in the Alabama Policy Institute lawsuit in state court, asked the district court to allow him to intervene as a defendant in Strawser. He told the court that in that other suit, the Alabama Policy Institute and the Alabama Citizens Action Program, acting in concert with and on behalf of the state of Alabama, are improperly attempting to seek further stay of this court's prior orders from the Alabama Supreme Court. On February 17, the Strawser plaintiffs asked the district court to enforce its order by requiring Attorney General Strange to prevent the private parties' suit in the Alabama Supreme Court from proceeding, contending that Strange has the authority to have the suit dismissed and that the court's order extends through the Attorney General to such private parties who seek to frustrate the court's order. Judge King made a similar motion. In response, Strange argued that he lacked such authority over private parties, that the plaintiffs had already received the relief for which they brought suit in the first place, and that the court's order did not require any action on the part of probate judges not named as defendants in Strawser. On February 20, Judge Granade denied King's request to intervene because he does not seem to have an interest in the subject matter of this action. She also denied the plaintiff's request that she order Strange to have the litigation initiated by private parties in the Alabama Supreme Court dismissed. She said the plaintiffs had not demonstrated they required further relief nor shown a link between the relief plaintiffs in this case had already received and the state court suit, whatever its outcome. More proceedings in Strawser. Final injunction in Strawser. On June 7, 2016, Judge Callie Granade issued a permanent injunction barring any state official from enforcing laws that fail to recognize same-sex couples' right to marry. Hedgepeth v. Davis. Late on February 9, the attorneys in Searcy filed a new lawsuit, Hedgepeth v. Davis, on behalf of 8 couples denied marriage licenses in Mobile County on February 9. They named as defendants Davis and 2 of his staff, Governor Bentley, Attorney General Strange, and Chief Justice Moore. They sought an emergency injunction and sanctions. Davis asked the Alabama Supreme Court for further instruction in light of the U.S. Supreme Court's action and the contempt motion filed in Searcy, which had already been dismissed, a request the court rejected on February 11, calling it a request for an advisory opinion, which the court is only authorized to give to the governor or legislature. The district court denied the Hedgepeth plaintiffs immediate relief for procedural reasons, but invited their attorneys to participate in the February 12 hearing in Strawser. After Mobile County began issuing marriage licenses to same-sex couples, the plaintiffs agreed to remove county officials as defendants, leaving only Strange and Moore. On March 24, having obtained marriage licenses, they asked that their suit be dismissed. Alabama Policy Institute lawsuit. On February 11, 2015, 2 conservative groups, the Alabama Policy Institute and the Alabama Citizens Action Program, filed a lawsuit asking the Alabama Supreme Court to order the state's probate judges to deny marriage licenses to same-sex couples. The suit targeted all the state's probate judges, but identified only 4 of them by name. On February 13, Equality Alabama filed an amicus brief asking the Alabama Supreme Court to dismiss the Alabama Policy Institute's lawsuit. It argued that the plaintiffs had not demonstrated a specific injury they had suffered and were seeking improperly to assume the role of state officials. The court gave the 4 named defendants until February 18 to file briefs, allowing the plaintiffs until 10 and February 23 to respond. One defendant, Judge Davis, argued that the lawsuit assumed no probate judge was subject to Granade's orders and could not apply to him now that he was a defendant in Strawser. Judges Alan King and Tommy Ragland offered arguments much like those of Equality Alabama. On March 3, the court ruled in a 7-1 decision that the plaintiffs had standing and that Alabama's ban on same-sex marriage does not violate the U.S. Constitution. It ordered all probate judges to conform to Alabama law and deny marriage licenses to same-sex couples. The court asked Judge Davis, since he was subject to Granade's orders, to explain by March 5 whether he was required to issue licenses to same-sex couples, in addition to those he had already issued to the Strawser plaintiffs as required by the federal court. On that date, Davis asked the court for additional 10 days to respond. On March 11, the court rejected Davis' request for an extension and ordered him not to issue any additional marriage licenses to same-sex couples. Following the Alabama Supreme Court's order of March 3, Judge Davis kept Mobile County's Marriage License Bureau closed. On March 18, probate judge Stephen Reed of Montgomery County asked the court to amend its order so that it becomes ineffective if the U.S. Supreme Court rules that a state ban on same-sex marriage is unconstitutional. The court denied his request on March 23 without comment. Searcy v. Davis. On February 24, 2015, Carrie Searcy asked the district court for an injunction against probate judge Don Davis, who had issued an initial adoption decree as ordered in Searcy v. Strange, but added language stating that this decree is qualified in nature, and the court will not issue a final adoption order until a final ruling is. On March 24, she told the court that Davis had removed the language in question and asked the court to dismiss her suit. U.S. Supreme Court ruling. On June 26, the U.S. Supreme Court ruled in Obergefell v. Hodges that the denial of marriage rights to same-sex couples is unconstitutional. Alabama Attorney General Luther Strange wrote in a news release, "While I do not agree with the opinion of the majority of the justices in their decision, I acknowledge that the U.S. Supreme Court's ruling is now the law of the land." Some probate judges began issuing marriage licenses that day, including those in Birmingham and Mobile, while others denied licenses to same-sex couples or issued no licenses to anyone. On June 27, 2015, the Alabama ACLU asked the state's Association of Probate Judges to instruct its members to comply with the ruling. As of June 29, 2015, at least 32 of the state's 67 counties were issuing marriage licenses to same-sex couples, and at least 22 of the counties were either refusing to do so or were refusing to issue marriage licenses to anybody. Also on June 29, the Association of County Commissions, an organization that provides liability insurance to judges, recommended that judges follow the ruling of the U.S. Supreme Court. After the release of the Obergefell decision, Justice Moore stated that the decision was subject to reconsideration for 25 days and until then not binding, while the Alabama Supreme Court was within that time frame asking for briefs with respect to its own order in the Alabama Policy Institute lawsuit that clerks not issue marriage licenses. He later issued a clarification: "In no way does the Alabama Supreme Court's order instruct probate judges of this state as to whether or not they should comply with the U.S. Supreme Court's ruling in Obergefell." On July 1, the Strawser plaintiffs asked Judge Granade to clarify the status of her order, and the same day she did so, issuing an order that said her preliminary injunction was now in effect and applied to all the state's probate judges. Counties issuing or refusing to issue licenses. February-March 2015. By February 18, 2015, 47 of Alabama's 67 counties had started issuing or announced they would issue if asked same-sex marriage licenses as follows. Counties that issued same-sex marriage licenses: 47 counties, 82% of residents. 2 others had stopped by this date. Autauga, Baldwin, Barber, Blount, Bullock, Butler, Calhoun, Cherokee, Chilton, Coffey, Colbert, Conecuh, Coosa, Crenshaw, Cullman, Dale, Dallas, DeKalb, Etowah, Fayette, Franklin, Greene, Hale, Henry, Jackson, Jefferson, Lamar, Lauderdale, Lawrence, Lee, Limestone, Love. 11 counties, 10% of residents. Chambers, Clay would not issue unless ordered to directly. Cleburne, 9 counties, 8% of residents. But no decision could be made while judge out sick. Choctaw, Clark, Geneva, Houston, Marshall scheduled, changed mind. Pike, Randolph, Walker. Some general reports indicated that Choctaw and Houston counties might be issuing licenses to opposite-sex couples only, but local reports in Houston were that it had instead stopped all licensing. Pickens had been scheduled to start issuing same-sex licenses on February 16, but it was neither reported to have actually started issuing licenses nor included among the counties such as Marion and Marshall that had similarly scheduled but reversed their decision. Counties stopped issuing marriage licenses to same-sex couples. On March 3, 2015, the Alabama Supreme Court ordered all probate judges in the state to stop issuing marriage licenses to same-sex couples. By the afternoon of the next day, all or nearly all counties stopped issuing such licenses. Autauga, Macon, Mobile, and Talladega stopped issuing licenses to all couples. Choctaw and Geneva, which had earlier issued no licenses, started issuing licenses to opposite-sex couples, while Bibb, Clark, Houston, Marshall, Pike, Randolph, and Walker continued in not issuing licenses to any couples. After Obergefell v. Hodges legislation. On September 16, 2015, the Alabama House of Representatives voted by 53 votes to 36 in favor of a bill which sought to do away with state-issued marriage licenses. Supporters argued the bill would protect probate judges who oppose issuing marriage licenses to same-sex couples. However, the bill failed as it needed a two-thirds majority. It received 59.6%. The Alabama Senate had previously approved the legislation. On March 15, 2016, the Alabama Senate approved a similar bill in a 23-3 vote. This time, a two-thirds majority was not needed. The bill, however, died without a vote in the House. A similar bill also failed in 2017. On January 16, 2018, the Alabama Senate approved another bill. It was passed 19-1. Senator Phil Williams was the sole senator to vote against it. The bill also died at the end of the legislative term, as the House had not voted on it. In May 2019, the Alabama legislature passed a bill replacing marriage licenses and ceremonies with marriage certificates in order to keep probate judges from violating their consciences by presiding over ceremonies of same-sex couples. The bill requires that every county issue marriage certificates, replacing the wording that probate judges may issue marriage licenses. State Senator Greg Albritton, who pushed for this new bill, said he saw this as a necessary compromise between the two sides of the issue. All counties in the state, including the final 8 holdouts, began issuing and recording marriage certificates to all couples who meet the requirements to wed on August 29, 2019. Roy Moore's order. On January 6, 2016, Alabama Chief Justice Roy Moore again ordered Alabama's probate judges to stop issuing marriage licenses to same-sex couples. Moore said the 2015 United States Supreme Court decision differs with earlier opinions by the Alabama Supreme Court, and the Alabama Supreme Court needs to clarify the situation. Moore added that the decision did not invalidate the state's constitutional amendment, and that the decision only invalidated the bans in the states which were parties in the case: Kentucky, Michigan, Ohio, and Tennessee. However, only 5 probate courts were known to have followed Moore's order: Elmore, Madison, Marengo, Mobile, and Walker. 3 of those counties, Madison, Mobile, and Walker, resumed issuing marriage licenses to same-sex couples a few days later. His statement had no effect, and all Alabama counties continued either issuing marriage licenses to all couples or not issue licenses at all. In May 2016, Moore was charged with ethics charges by the State Judicial Inquiry Commission for the ruling. On 30 September, Moore was found guilty and suspended for the remainder of his term. Alabama Supreme Court's orders, order, court's order, orders, order, court's order, court's orders, order, 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 court's order, order, ordered. On March 4, 2016, the Alabama Supreme Court issued an order dismissing a case brought forward by the Alabama Policy Institute, the Alabama Citizens Action Program, and the Elmore County probate judge, although in terms that left it unclear whether the court was acknowledging Obergefell as the law. The intended effect of the opinion was unclear, although it appears to acknowledge the invalidity of Alabama judicial decisions post-Obergefell that attempted to challenge that decision. It does not expressly acknowledge Obergefell as the law and instead argues that Obergefell is invalid. All motions/petitions that were filed subsequent to the original mandamus order are dismissed, technically leaving in place the original decision. But that decision, according to Justice Shaw, is a dead letter in light of Obergefell and the Strawser injunction which binds all probate court judges in Alabama, noted the legal director for the American Civil Liberties Union of Alabama. The founder of evangelical Christian litigation group Liberty Counsel agreed that the judgment makes permanent the Alabama Supreme Court's order prohibiting probate judges from issuing marriage licenses to same-sex couples, adding that the Alabama Supreme Court has rejected the illegitimate opinion of 5 lawyers on the U.S. Supreme Court. While the intended effects of this, Judge Greg Shaw's concurrence was cited as commenting that the Alabama Supreme Court was bound to abide by the judgments of the U.S. Supreme Court, and noting that judges that failed to recognize that should resign. Final holdouts. As of October 2, 2015, at least 8 counties were not issuing any marriage licenses, with no indication if or when they might resume: Autauga, Choctaw, Clark, Cleburne, Covington, Geneva, Pike, and Washington. Chambers and Bibb counties confirmed on August 21 and September 4 that they were not issuing any licenses. By June 26, 2016, Chambers had begun issuing marriage licenses to all couples. Elmore, Madison, Marengo, Mobile, and Walker stopped issuing marriage licenses on January 6. However, Madison, Mobile, and Walker began reissuing marriage licenses to all couples a few days later. Following Judge Granade's final injunction in the case of Strawser v. Strange in June 2016, probate courts from both Clark and Washington reiterated. A few days ahead of the first anniversary of the Obergefell v. Hodges decision, the American Civil Liberties Union of Alabama found that 12 Alabamian counties were still not granting marriage licenses to same-sex couples. 11 of these counties issued no marriage licenses at all, either to opposite sex or to same-sex couples: Autauga, Bibb, Choctaw, Clark, Cleburne, Covington, Elmore, Geneva, Marengo, Pike, and Washington. Coosa County continued to deny marriage licenses specifically to same-sex couples, citing technical difficulties but admitting that it had no plans to remedy the situation. By October 2016, the counties of Bibb, Coosa, and Marengo had begun issuing licenses to couples regardless of gender, while the other 9 counties continued to refuse to issue any licenses. At least 6 counties which were issuing marriage licenses nevertheless refused to preside over any marriage ceremonies. In June 2017, Wikipedia confirmed that Choctaw County had begun issuing marriage licenses to all couples. 2 years after the Obergefell v. Hodges decision, 8 Alabamian counties still refused to issue marriage licenses to any same-sex or opposite-sex couples: Autauga, Clark, Cleburne, Covington, Elmore, Geneva, Pike, and Washington. By June 2018, the same 8 counties were still not issuing marriage licenses. The situation was unchanged as of May 2019. All 8 remaining counties began issuing marriage certificates on August 29, 2019, following a change in state law replacing marriage licenses and ceremonies with marriage certificates in order to keep probate judges from violating their consciences by presiding over ceremonies of same-sex couples. Marriage statistics. According to the Alabama Department of Public Health, at least 545 same-sex couples obtained marriage licenses and wed between February 9 and March 3, 2015. By the end of 2015, 1622 same-sex marriages had occurred in the state of Alabama. These marriages accounted for about 4% of all marriages performed in the state that year. 936 and 715 same-sex couples married in Alabama in 2016 and 2017, respectively, with Jefferson, Montgomery, Madison, Mobile, and Baldwin counties being the most popular. 2018 estimate: 61% involved married couples. Public opinion.